Right, this is Wayne County Humane Society versus Smith, and both sides will have 15 minutes to present their arguments, and the appellant may reserve up to 5.
Thank you.
Thank you. Just let me know, Mr. Bazzelli, if you want to reserve
If
time.
I may, I'd like to divide my time by 7 minutes and 8 minutes.
Okay, we only allow 5 minutes, I'm sorry. We do 10 and 5. if you
Then
want.
5 and 10. Thank you.
Thank you. Go ahead.
Thank you. First of all, good morning, Justices. My name is Russ Bazzelli. I represent the appellant in this case, Jane Smith. Would the court require a factual recital at this time or rely upon the brief presented?
Whatever, you have the time is at your discretion to use however you feel more comfortable presenting your argument.
With that, then, I'm going to move directly to the arguments in this case.
It's fine.
First and foremost, it is the position that the due process denials that took place in this matter deprived Jane Smith of a fair trial. Jane is accused of being an animal hoarder, yet the evidentiary rulings of the court in this case prevented her from defending against those. It began with records that Jane Smith kept at Bright Futures Rescue on a daily basis, business records. She was unable to present to the court records that involved 10 years of good marks from the Humane Society because those records were not produced in discovery by the state. She was unable to present the vet records that she kept in the normal course of business, showing, in keeping with the statement of Diane Hudson, the humane officer, that these animals were well-fed, well-hydrated, and she wouldn't be surprised if they were well-fed. We were not permitted to bring in all of the expenditures, line item, that Jane spent on veterinary care. As I said in my opening in this case, it wasn't a pretty operation, but it wasn't a cruelty operation. With that, the other items that the record provides start with part and parcel the inability to challenge the case against Jane Smith, and that starts with the search warrant in this case. The appellant alleges that the search warrant was gained by illegal state action. I've never used those words in over 29 years of practice, and I had to be surefire certain before I did use them. But then when I had Mr. Gibson on the stand under oath, he admitted to not one, but to 2 burglaries. In addition to admitting to those 2 burglaries, he told me that he met with the director of the Humane Society on a day, a Monday, when they're closed. And it just so happened he comes here all the way from Youngstown by coincidence because he's looking for an alleged stolen dog, which, by the way, the record is devoid of any proof of. And he meets with the director and the county's only Humane Society officer. And at that point in time, he is told the state needs better evidence to get a search warrant. And say, you know, we may want to do this, we may want to do that. The direct words coming from Mr. Gibson, he knew when he left, he knew that he needed better evidence. And we also know that we have 2 individuals, one who was a law enforcement officer who was aware that one crime had been committed. Because remember, as the record reflects, the humane officer, Ms. Hudson, had already been to this residence. She was aware that it was posted no trespassing. She knows it's a home. She knows that this individual, Mr. Gibson, had already once entered part of that dwelling. And he did it a second time when he produced pictures. She knew another crime was going to be committed, and it was directed, no matter how circuitous you want to make it, by the director of the Humane Society, Mr. Mykrans. As I understand the case law, when you direct an action of this regard, when you don't prevent a second crime, when you know a second crime will have to be committed, you are not a neutral observer. You are an active participant. I understand that to be an accessory. That's what criminal law provides. As it relates to the other denials of due process, going past what I perceive as the lack of a Frank's analysis, which didn't take into account all of the issues with respect to a stale search warrant, which dealt with a claim that was never verified about a dead animal, about other claims that were put forth that were part of a non-prosecution agreement. It appears that Jane was again denied due process. There are two types of non-prosecution agreements. The court is aware of that: judicial, extrajudicial. This was an extrajudicial. There was even a contract that's in the file. It comes from the signed document that Jane signed in January. What were the words of Mr. Mike Kranz? We try to get these people to cooperate, then we educate, then they graduate. He stated that Jane was compliant in this agreement, that she did what was asked of her. She called in March for the recheck, and what were the words of Mr. Mike Kranz? It was a low priority for us. We were going to get to it. Well, it wasn't a low priority. In fact, it was part of the plan. They were, as stated in the record, looking for a way to get into Jane's house. They breached their agreement. They anticipatorily repudiated their agreement. And as such, I would ask that agreement be enforced, because as the court is already well aware, in these types of agreements, the law of contracts provides. We're beyond section 45 of the Restatement of Contracts second. We're into section 90, and they should be stopped from not putting this agreement into effect. As it relates to the other denials, we have records. We have records of inspections. We have records of vets. We have records of the adoption process. We have pictures. We wanted to bring in these actual adoptions that have been taking place for over 14 years. We were limited to 2 weeks. We were limited to 3 adoptions. We had pictures of over 100 animals, but we weren't permitted to present them. If we can't discuss the adoption process, we cannot attack this claim of hoarding, a denial of due process. We can't cross-examine the witnesses. We can't ask...
Mr. Bazzelli, excuse me. I have a question on the pictures that were excluded. How old were those pictures in terms of, I understand the operation was a very lengthy one, had been operating for a long time, and that, were the pictures recent, or did they go back?
We had both. We had recent and ones that went back 4 years.
All right.
And those were not only pictures that my client had taken, but also pictures from, I'm sorry.
Well, mine did it too.
That's my timer. Just also pictures that were not only from my client, but also Pet Finder, where she puts these animals up for adoption.
Right.
And we couldn't even
Thank you.
as I'm coming up on the end of my time here, I would just say, in addition to those items, she was unable to discuss the other animals. She was unable to bring in evidence from the state's own vet, Dr. Riggs, who said the birds were in good shape, and that's key. Because the challenge here was that this was a bad aerobic environment. And as we all know from our science classes, birds breathe by air sacs. And if the aerobic environment is bad, the birds are sickly or die. It's not fake, it's science, it's real. And our own expert, Dr. Mabry, was prevented from testifying to that. He said all animals were healthy, that includes the birds. We couldn't talk about the healthy horses, we couldn't talk about the healthy chickens, we couldn't talk about the healthy cats. And we're put in this artificial environment where all they're dealing with are claims of a smell and claims of lack of veterinary care, which is contrary to the state's own case. In summary, we couldn't attack those items as it relates to the claims of hoarding. We couldn't attack, from a standpoint of cross-examination, witnesses who, as the court already knows, and without going too far, Miss Mary Jo Johnson, who has been before this Court of Appeals before in a sex slave case. I couldn't cross-examine the state's esteemed hoarding expert on this issue, nor her lack of education. My client was deprived from beginning to end of due process and a fair trial. Thank you.
Thank you. You have 15 minutes, you may proceed.
May it please the court, Mr. Bizzelli. My name is Olivia Boyer, and I represent the appellee, the state of Ohio, in this case, State of Ohio versus Jane Smith. The counsel for appellant addressed a number of issues which I would in turn like to address now. First and foremost, Ms. Smith was not charged for being an animal hoarder. While that was discussed by the state's expert, Mary Jo Johnson, what Ms. Smith was charged with was a violation of Ohio Revised Code, section 959.131E2, that she omitted any act of care by which unnecessary or unjustifiable pain or suffering is caused due to the lack of care. The state presented at trial 3 experts, Dr. Janetta Quinn, Dr. Brian Wennerstrom, as well as Dr. Maybury, who all testified that consistent with what they observed, including the photographs of the condition these animals were kept in, the parasite infestation rates, which were 60%, as testified to by Dr. Quinn, as well as Dr. Maybury sitting in court for the 4 days of trial, listening to all the evidence and all the witnesses. These 3 veterinary experts were able to determine that the animals in Ms. Smith's care, the 47 dogs for which she was charged, were suffering due to a lack of care. And the lack of care was expounded on during the trial. These animals weren't vaccinated. 60% of the animals approximately had some type of parasitic infestation rate. Dr. Quinn testified that across the board, no matter where you find an animal, whether it's feral, whether it's on your couch at home, whether it's just lost and running at large, that there's a 2 to 3% parasitic infestation rate for animals across the board, yet the animals in Ms. Smith's care were 60%. This was not an animal hoarding case, this was an animal cruelty case. Now, as to the search warrant, I would ask the court to look at its previous decision from 2001, State v. Knapp. In State v. Knapp, it was determined that the actions of a private individual reporting that there was a marijuana grow on her property was not tantamount to state involvement in an illegal search, even though there were law enforcement officers present with the property owner and walked through the property. Even under those facts, this court previously determined that that was insufficient to rise to the level of government action. And what do we have here in the present case? In the present case, Robert Gibson, who testified under oath multiple times at the suppression hearing as well as at trial, that he was looking for his lost dog, Max. He had flyers, those flyers were produced at trial, and that he stumbled upon the Pet Finder website of Ms. Smith, thought he found a dog that matched Max's description, appearance, photograph, everything. So he went to the residence looking for his dog. This was information that he found publicly. It was available online. Anyone in a similar situation to Mr. Gibson could have found it. He went there expecting to find an animal rescue. He found quite the opposite. He described the odor that he observed, how it impacted him, how it burned, how it was ammonia-laced. And based on what he saw, crates of animals stacked 3 high, he went to the Wayne County Humane Society in order to seek assistance for those animals. I would ask the court to look at the transcript from the July 9th suppression hearing. Stuart Mykrantz testified that he never instructed Mr. Gibson to return to the property, and the trial court found that to be credible. The trial court found Mr. Mykrantz's testimony, as well as Mr. Gibson's testimony, that there was never a discussion of Mr. Gibson returning to the property credible. Given that, the action of Mr. Gibson was a private search. It did not rise to the level of state involvement and state action. Now, did the Wayne County Humane Society, in securing a search warrant, use the information provided by Mr. Gibson? Yes. But that's because he was a witness who underwent a private undertaking, not tantamount to state action. Now, I'd also like to draw the court's attention to the non-prosecution agreement. If you look to page 82 of the July 9th transcript, the suppression hearing that was held in this manner, Mr. Bizzelli was cross-examining Stuart Mykrantz and was asking about the non-prosecution agreement, and the state objected. I objected to the lack of foundation that was laid, as well as the categorization of the Cooperate, Educate, Graduate program as a non-prosecution agreement. There was no response from defense counsel about that objection or any foundation laid as to that being a non-prosecution agreement. And frankly, it wasn't. It wasn't a non-prosecution agreement. The Wayne County Humane Society's Cooperate, Educate, Graduate program is a program that they use in order to work with animal rescues who may not have the conditions appropriate for the animals. It's an attempt to intercept and to prevent charges to be later filed. It's not a non-prosecution agreement. Also, if you look to the trial transcript from this matter, if you look at page 63 and 64, there was a plea offer made, and that was the only plea offer that was ever made to the defendant. And that plea offer was that the defendant plead to 1 count of animal cruelty, 1 violation of 959.131. The state also expounded what the sentencing recommendation would be in this particular matter. That was it, and that was rejected. So to now ask for a non-prosecution agreement to be enforced when there was never one in existence other than the plea offer that was documented before trial simply doesn't make sense. It doesn't have any foundation in the law. There was no non-prosecution agreement. Now, returning to the limited pictures, the court did exclude a number of items as being irrelevant in this matter. The defendant was charged with 47 counts of animal cruelty for the 47 dogs that were in her care. A number of exhibits that were proposed by defense counsel and the defendant were merely irrelevant. The photographs that were excluded, there were some photographs excluded at trial. They were excluded because they were black and white. They weren't an accurate depiction. And when you look at the color photographs from the scene, you can see the dirt, you can see the filth, you can see the feces that these animals were forced to live in during the care provided by Ms. Smith and the lack of care that she committed on these animals. Mr. Bazzelli categorized the expert for Ms. Smith's report as saying that all animals were healthy. That's not the extent of what his report stated. His report stated that there was insufficient evidence to determine cruelty based on the evidence that he reviewed. But if you look at all the experts that the state presented, and the state did have 3, the state's experts were able to say, based on their training and experience as a veterinarian, that there was sufficient evidence for there to be a finding of cruelty. Now, I'd like to specifically address the due process claim that was raised by defense counsel. If you look at 959.132E1, there is due process here. There is due process. While appellant didn't raise the property interest in her brief, even if you assume that there is a property interest, 959.132E1 outlines the General Assembly's intention for there to be a hearing in this matter to address the due process claim, the property interest. And the court, 10 days after the animals were seized, the court did have a hearing. And at that hearing, the trial court determined that there was sufficient evidence for these animals to be seized and removed from the conditions that they were in. That's the process that's due to the appellant. And that was satisfied by the trial court. Now, appellant has raised that the statute's vague. However, in order for a statute to be vague, the statute must not fairly inform a person of what is prohibited. However, the statute for which the defendant was charged under, 959.131, it's explicitly clear. No person shall omit any act of care by which unjustifiable pain or suffering is caused when there is a reasonable relief. Dr. Jeanette O'Quinn testified that there was a reasonable relief, an alternative for these animals. You could vaccinate them, you could groom them, you could let them out so they can relieve themselves. Dr. O'Quinn also testified that crate training is a method that can be used for animals, and only under the most severe circumstances will an animal defecate in its own cage. Well, what was found at the scene of Ms. Smith's home on May 19, 2014? There were crates stacked 3 high, consistent with what Mr. Gibson reported. There was fecal matter caked around the cages of the animals. These animals were forced to live in abhorrent conditions, and those abhorrent conditions resulted in several parasitic infections for these animals. Now, going back to the procedural issue that Mr. Bazzelli raised, that the prosecutor failed to provide all evidence, I'd like to address that. The appellant's alleging prosecutorial misconduct that deprived Ms. Smith of the right to a fair trial. However, the appellant has failed to show how they were prejudiced by any alleged prosecutorial misconduct and not providing material under the rules of discovery. Dr. Wennerstrom was the expert that initially saw these animals. He was a Wayne County Humane Society veterinarian, and when the animals were seized, he was the first to assess them and review them. During the trial, and I'd asked the court to look at the trial transcript, Dr. Wennerstrom was cross-examined extensively by defense counsel at trial level about the 2 reports, about whom he met with. Now, Mr. Bazzelli is alleging that Jeffrey Holland, an attorney whose expertise is animal cruelty, needed to be listed as a witness. Mr. Holland was secured by the Wayne County Humane Society in order to assist for trial preparation. That's clearly work product. That's not discoverable material. Mr. Holland didn't issue a report. He worked with Dr. Wennerstrom, and Dr. Wennerstrom creating his report. And Dr. Weinstrom was asked about that at trial. And in response to Mr. Vizelli's inquiry of what were you told to put in your report, Dr. Weinstrom said, I was told that the most important thing is the truth, that this needs to be my own words, my own opinion based on my expertise. And Dr. Weinstrom testified under oath that that's what he put in the report. There simply wasn't any prosecutorial misconduct that deprived Jane Smith of her right to a fair trial. In fact, there wasn't any prosecutorial misconduct. All the material that the state had was presented, was provided, was available for inspection to defense counsel at the trial level. The defendant had an opportunity to review everything. And in fact, the majority of the records that defense counsel at trial level alleged that they didn't have access to were the type of records that the appellant would have had in her possession to begin with anyways, and would have never been in the possession of the state. Given that, Your Honor, I would ask this court to deny the the relief sought by appellant. They simply haven't provided the necessary argument or evidence to this court in order to be successful. Thank you.
Thank you, counsel. You have your 5 minutes remaining.
5 minutes? Thank you. In addition, Jane was prevented from being able to attack the credibility of all witnesses from the Wayne County Humane Society. We were not permitted to go after their financial instability. We had financial records that we provided. We attempted to show that they had monetary problems. We attempted to show that they had just lost the dog contract, but we were prevented from going after this information because we were told that even though it may show bias, but it would confuse the issues. Again, Jane is denied due process. What also isn't mentioned is the fact that during the trial itself, the prosecutor takes a bag of fully formed and fairly formed dog poop, and over objection is permitted to allow people to look at it and smell it. Having grown up working on a farm, I can tell you that a milking parlor at around 6 in the morning or 4 in the afternoon smells a whole heck of a lot worse than any dog rescues, because these are animals that are kill animals. We couldn't say that. These are animals that are scheduled to be killed, and people like Jane Smith save them and put them into forever homes, and there's a price. She sacrifices other parts of her life. There is an unconstitutional taking of her property. She's charged $17,400 per month for the care of these animals, where she was able to take care of them for 14 years on a salary of $50,000. This statute permits taking before justice. It needs to be stricken down. Also, if you look at the comparison of section 959.13 to section 959.131, one is a misdemeanor of the second degree, one is a misdemeanor of the first degree. These are animals, whether you call them wild animals or you call them domestic animals, they are animals. There's no differentiation other than statutory language. There's no difference, reason, it is vague, as to why you would treat these two classes of animals that are the same thing, animals, differently. With that, this statute 959.131 appears unconstitutional. Finally, when it comes to the issue of discovery violations, yes, we weren't told about the second report. We weren't told that there was no additional evidence that went into the making of the second report. We weren't told that Jeffrey Holland, another expert, was involved in the making of this report, a witness. We weren't told that the prosecutor was also involved in the making of this second report, another witness. She didn't disclose herself as a witness, a discovery violation in that regard. As it relates to the actual issues remaining, we go to the claim of state action. That is a totality of the circumstance review, as the Dirch case, the Byers case, the Weeks case all appear to point out. And in this case, as stated by a justice of the United States Supreme Court, it appears the constable has blundered because he used circuitous methods to get what he and everybody admitted in the stand they wanted, access to Jane's home. As it relates to the statutory framework that is before the court, I won't repeat those arguments, but when you can't cross-examine, when you can't stop the use of a bag of dog poop to inflame the jury, where the court changes its sentence after it's already lost jurisdiction in a case, these denials of due process add up. And what's quite troublesome is that we even filed a motion for a stay of execution of sentence in this case. The record appears to reveal it never made it to this honorable court, although we argued it and were denied in the trial court. So from beginning to end, there's a denial of due process. Based upon that, I ask on behalf of my client that these convictions be deemed obtained on insufficient evidence insofar as the motion to suppress should be reversed. If that is granted, I ask this case be remanded with instructions that the defendant's charges be dismissed with prejudice, an order that directs all of the defendant's monies be returned and all rescued animals be returned forthwith. Alternatively, if the court believes that there has been a denial of due process, I would ask for a reverse and a remand and for an order for a new trial. Finally, I thank the court, and as it relates to my client, excuse me one second. I would just posit for the record that I was just advised that there are new records in this case. This would be a motion that I would put before the court for newly discovered evidence. These records were provided to me a day ago. I have not reviewed them. I will only tell the court that they show all the animals that were claimed to be abused are listed by Wayne County Humane Society as being normal. Thank you.
And thank you, counsel, but I would be derelict if I didn't inform you. Of course, you realize we can't consider any new evidence. You know what your remedies are if you feel that you have some.
I understand, and I thank the court.
Thank you.
I thank the court again for its time, for its patience, my confidence, my colleague in this regard. Thank you.
Thank you. The court will take the matter under advisement. Written opinion will be prepared and be sent to both sides, as well as we will release our decisions on our website and the Supreme Court website, and you can access them electronically. Thank you very much for your kind attention to this matter.
Thank you.